Welcome to Deals and Disputes with the Webb Law Group.
Hello and welcome back to Deals and Disputes with Webb, Albritton, and Gentry. Today I'm joined by Hanna and Melissa Koelsch, attorneys with the firm whose practice includes employment disputes in higher education law. I'm Evan Mack, and today we're talking about how new laws taking effect in 2026 impact employees and workplaces in Texas. Ladies, how are you?
Doing well. How are you?
I'm well. To kick us off, can you give a big picture overview of why the start of a new year is such an important time for legal changes?
So the thing with the new year is there's a lot of laws that go in effect on January 1, 2026. Oftentimes you'll see laws taking effect at three, I would say, key times throughout the year. Mm-hmm. September, when legislation sessions tend to end, December, and then January 1. It just makes it easy in a lot of ways for businesses, employers to function. And so that's what makes the new year particularly important for legal changes, because you are seeing a lot of new laws come into effect that people need to be aware of.
Are there any new law changes this year that are especially relevant to Texans, even if they don't realize it yet?
Yeah, there's several. And so we've got quite a few employment and business ones we're going to talk today about, since that's the focus, obviously, of the podcast. But there's a couple, more niche ones that I think are important to bring up in answering your question. So two big categories there: AI, which is just a general hot topic, right, as we are entering this new tech era. And so there's a few Texas AI bills that passed. So there's House Bill 149, which is going to talk about artificial intelligence regulation. Wow. And Texas is one of the first states that's actually passing laws on AI usage. And so I think we're going to see a lot of other states following suit in the years to come, and a lot of changes. So the Texas bill that just passed is talking about prohibitions on AI systems that generate explicit content and manipulate human behavior through violence, maybe political messaging. We're seeing a lot of that on social media. It's been a hot topic. Now, keep in mind, this is currently focused on government, but I think we're going to see the trickle-down effect from this. So that's one big change regarding AI that's gone into effect here in the state of Texas. There's another bill that's currently blocked, but it was an AI bill that was requiring age verification for new app downloads. That's been blocked by a federal judge in Texas based on First Amendment violations of free speech. So no clear answer yet on that, on whether or not it will be coming back around. But if it does, what parents will be seeing is that their kids can't just download anything off the internet from the App Store without verifying their age. Now, our kids are smart. They'll get around that one. But those bills do exist. So we'll see how that plays out in the next, in the coming years. So that's kind of one topic I think that's really important for people to know about. And then another area is immigration. Now, we're not immigration attorneys. I'm not going to represent that we're experts in this field, but with everything that's going on, I think, in the nation, in media, Minnesota, everything that's going on there with ICE, I think it's really important for Texans to be aware of. So in the last election cycle, we passed Senate Bill 8, or Senate Bill 8 was passed. And this is going to require sheriff's offices in counties of populations over 100,000 people to, cooperate with ICE as they come through. And they have to do what's called a 287G agreement. Wow. It's up to the sheriff's office, so vote. As a reminder, those sheriffs are elected. But those sheriff's offices are going to pick programs for cooperation with ICE. And there's three kind of programs that are going to be instituted. The warrant service model, which is going to authorize deputies, so sheriff deputies, to execute immigration-related warrants or detainers within the jail setting. Okay, so it's really limited to the jail setting. If you're arrested and you're in the jail, the sheriff office can verify your immigration status. And then there is the jail enforcement model, where sheriff's deputies can interrogate individuals about immigration status once arrested. And then the highest level is the task force model, which is in which sheriff's deputies will be, they can engage in a broader immigration enforcement outside of their normal jurisdictional limits. So you're going to see voters in Texas are going to see a lot more engagement with ICE because this bill that passed is mandatory, and all sheriffs county or all sheriff's department within the state of Texas over 100,000 have to participate by December 1, 2026. They have to elect which one of these three programs are they're going to institute. And then in response to that, there's a grant reciprocation. They'll get some money to help fund that program. And then smaller counties can elect to participate. And I think we're going to see a lot of smaller counties in Texas do that as well. So those are just two kind of broad areas, AI and immigration ICE, that I think are relevant to Texans just across the board that they should all be aware of.
Wow, but so from an employment law standpoint, what updates should employers be paying attention to as they head into 2026?
So I'm going to take that one as well. And there's quite a few areas, one in which that's going to directly impact employers, and then just a few on the peripheral that I think employers just need to be aware of. So the major one is House Bill 3699 regarding unemployment claims. So this new law that passed expressly defines the claimant's last work or their last employer. So it's creating a more clear process when an employee, or a former employee is making a claim for unemployment benefits. Okay. So what that's doing is it's putting an obligation then on the employer to pay attention when they receive notification from the Texas Workforce Commission regarding the individual making unemployment benefits. Okay. So that's important for that employer to pay attention to make sure that maybe they're the right employer. Okay. They don't want to be paying, unemployment benefits out to an employee that was not, probably a better way to articulate that is you as an employer don't want to be paying out benefits if you were not that last employer that created the unemployment framework. Okay. So that's really important to be paying attention to. And then a couple others I mentioned that, like I said, were just a little peripheral, want to be aware of. Insurance notice requirements have changed in the state of Texas. So employers that are maybe self-insured or interact with insurance companies need to be aware of this because the new law is going to require the insurance companies to give written responses as to why they're declining, canceling, or refusing to renew policies. So it's just something to be aware of because it could be changing employers, maybe internal structure on how they're handling insurance claims, etc. And then there's also actually a business change in the business tax allowance that's going into effect that's going to be really important for businesses, employers, et cetera, to be aware of. Again, a little on the peripheral, but I think it's important. So in the state of Texas, small business inventory, the tax exemption used to just be $2,500. Well, that's gone up to $125,000. So that's a big jump that employers, companies, entities need to be aware of when they're planning for their taxes in the coming years. So those are just a few takeaways that I think are important for employers to be aware of.
So are there any changes that might surprise employees, the things that affect their rights, benefits, or maybe those, workplace expectations?
So that's a great question. I think that all of these are going to impact those things, their rights, their benefits, their expectations, right? That they need to be aware of. But particularly, right, the increase in business inventory exemption and being aware of this change in unemployment benefits, that needs to be something that employers are thinking about and putting into place, procedures that they can refer to when they do get that next unemployment claim, because going about business as you had been in the past isn't going to work moving forward, where you're just ignoring, TWC, spam mail or emails. That's not going to fly anymore. And you could find yourself paying out or being obligated to pay out unemployment claims for an individual that wasn't your last employee. They had a prior employer that should actually be paying those unemployment benefits. So we really need to be cognizant of these changes.
So turning to property and real estate, are there new laws or rule changes that could affect homeowners, buyers, or landlords this year?
Yes, and I will kind of cover those. It's going to primarily fall on the landlords, and really willing or unwilling landlords in this case. A lot of really it's SB 1333, and then also SB or Senate Bill 38 that are new or recently going into effect. For two different purposes. Senate Bill 1333 is really geared towards preventing squatters, which is another way to say individuals that are unlawfully in possession of somebody else's property. So, and that's why I say the unwitting landlord, you don't have to have agreed to lease your property to somebody. If you find that somebody is on your property unlawfully, these new statutes will be relevant to you and also could help you recover that property faster. Particularly 1333 streamlines the process for a property owner to get an unlawful occupant of their property off. In the past, you had to go through the full process of filing an eviction suit. This new statute permits property owners to file a sworn complaint with their sheriff's office, who will then issue a notice to vacate the property and could allow them to regain possession so long as the current tenant is truly unlawfully there. And by that, I mean no deed, no lease, nothing like that giving them possession of the property. And the other change in the kind of eviction laws is Senate Bill 38, which was really an overhaul of a lot of our eviction procedures. So the process of evictions is purely statutory, which means you got to go to what the law books say when you're looking at timelines. It's all kind of geared from the perspective of you don't want to wrongfully remove someone from their home. Someone's living there in a lot of these cases, if we're talking residential evictions. But what Senate Bill 38 is, it has simplified some of those processes, given landlords, at least the intention behind it is give landlords a more streamlined, faster route to recovering their property, creating some deadlines as far as when those lawsuits can get to a final judgment. It's also allowed for a summary judgment phase if there are no fact issues in the eviction. There's been, I think, mixed responses on this. The other kind of downside of this is if you're streamlining a process for landlords, you could also be unintentionally removing people from their homes who may actually have a legal right to be there. And so some housing advocacy groups have spoken on this. We'll kind of see how this develops over time. And it's part of these new legislation as it comes into play. Sometimes you don't always see what the outcome is going to be, even though you know the intention, until after some time has passed.
So for those business owners, are there any legislative updates that impact the contracts and the partnerships in those day-to-day operations?
Yes. So really earlier in 2025, still in effect going now, there were some pretty big, substantial changes, pro-business changes, to the Business Organizations Code. Namely, in that we have codified the business judgment rule, which is that directors and officers of publicly traded companies in Texas are presumed to have acted in good faith on an informed basis, in the company's, corporation's best interests and in compliance with applicable law. What that means practically is that if you are a plaintiff filing a lawsuit against an officer or director of an entity, you now have the burden of rebutting that presumption. And practically that means if you're asserting a claim of fraud or intentional misconduct or ultra vires activity, you would need to prove that they knowingly engaged in this conduct, and you would need to plead that with particularity, as opposed to just a kind of blanket, they didn't do what they should have been doing. They're now presumed to have acted in accordance with the business judgment rule. Now, one thing to note with that, especially as we're starting a new year, is that only automatically applies to publicly traded Texas corporations. So LLCs, LPs, those entities need to opt into these provisions, which means for business owners, it's a good time to review your governing documents. It's a simple fix in the governing documents, but you want to make sure that you've got that covered so that you get the benefits of this new legislation change as soon as possible.
So, are there any probate or estate related changes that might prompt people to revisit their wills or estate plans in 2026?
So, with the probate estate side of things, I think typically when people are thinking about revisiting their estate planning, the start of the new year, you're looking at the estate tax exemption, which from 2025 to 2026, it was increased from 13.99 million to now 15 million. Typically, for high net worth individuals that have estate planning that is with the intention of keeping in mind this estate tax, that increase in the estate tax exemption probably won't rework their estate planning. Always something that they should confer with their or consult with their legal counsel on that. But that was the primary change with estate laws or applicable laws in this area. The other changes to kind of the probate procedure are more administrative, more attorneys know that they've changed. One of those being like statutory probate courts now have to send out orders by electronic service. Great for attorneys. We actually get these by email now, but the individuals, our clients, that typically doesn't change their day to day or require a new meeting with us.
So for someone who doesn't follow legislation closely, what are some of the common misconceptions about how new laws affect them?
I think one of the major misconceptions that individuals have is, oh, well, if I didn't know about it, right, I'm exempt. Okay. I don't have to stay on top of it because, feigning innocence, if that makes sense. Ignorance isn't going to save you here. So that thought process is not the way to approach law changes. You're going to have to stay informed, do your due diligence, stay on top of things, watch the news, whatever it is, and contact your attorney if you have any concerns. And oftentimes that misconception that, well, I didn't know, certainly doesn't affect me, is what leads to clients coming through my doors and getting into a long-standing relationship with me, which as a business owner is not where you really want to be spending your money, right?
What best practice for Texas consumers entering 2026 when signing contracts, buying property, or doing business is increasingly regulated, is increasingly regulated environment?
I wish there were a general rule we could give everyone as far as at this point you get to this threshold, you need to call an attorney. Unfortunately, that does not exist. My kind of general thought process on it is if you are buying and selling land, if you are entering into agreements that require you to perform or somebody else to perform for an extended period of time, or any sort of deal or transaction that is more valuable than what the cost of a consultation with an attorney would be, it's probably worth consulting with an attorney beforehand. There are many pitfalls down the road that you can avoid or at least be mindful of and try to avoid at least, that if you had talked to an attorney beforehand, you'd be able to do that. Looking at it in hindsight, once an attorney gets involved, it's a whole lot harder for us to go back and fix.
So what's one practical step listeners can take in January to make sure they're starting the year on solid legal footing?
Yeah, so I think it goes back to some of the things Hannah and I have discussed, right? Staying informed, knowing what laws have taken effect, and when in doubt, contact your attorney for a consultation. A lot of times I see clients that come in the door when they're deep in an issue, a legal issue, and they put off contact the attorney for a simple consultation because they thought, maybe not correctly, that, oh, well, if I contact that attorney, I'm getting into this long-standing relationship. No. A lot of times I have clients who come in for the consultation, I give them information or I point them in the right direction, and that's really what they needed. That consultation alone can resolve a lot of those issues, or maybe not resolve it, but really streamline that process moving forward. So my big takeaways are staying informed, know what laws are going into effect, and when in doubt, go ahead and take that step, pay the consultation fee, talk to your attorney about it. And hopefully that's it. And you can move on.
With that being said, when should someone consider calling an attorney to review how these new laws apply to their specific situation?
So I think we kind of touched on that previously. Obviously, if you are a business owner that is not a publicly traded company, you want to review your governing documents and talk to an attorney. If we have touched on anything that you think affects your day-to-day, either from a business perspective, from an estate planning perspective, if you have no estate planning, it's never too late to get that. The sooner the better. Even for young people, it's worth doing. And if you have questions about an agreement you're about to enter into, 9 times out of 10, it's better to have consulted with an attorney beforehand than to need us after the fact, after something's blown up, a dispute has arisen.
And finally, if listeners only remember one takeaway from today's episode, ladies, what would you want it to be?
So I think for me, it's going back to that consultation that we talked about. A lot of times I have clients that come in, and if they'd done that consultation, if they talked to an attorney at the beginning, they would have saved themselves a lot of headache, time, money, and effort. So that to me is the biggest takeaway. When in doubt, contact that attorney. Don't ask ChatGPT. AI does a lot of things, but it's not going to solve all your issues. So that's on my perspective, takeaway.
The only one thing I would add to that is kind of like we've said, is staying informed on this is both, it can protect you from potential liability. It's also a smart business move. It's not just limitations on what you can do. There are also advantages you can utilize in your business or as an employer or employee that if you don't know that they exist, you can't take advantage of it. And in the same way, ignorance doesn't protect you. It also doesn't allow you to do the most with what you're legally permitted to do. So staying informed, if you get to the point where you're kind of at the limit of what your expertise can kind of inform you on, it's a great time to talk to an attorney. And kind of like Melissa said earlier, a consultation does not sign you up for years of paying for that attorney. Sometimes it is just a useful step at the front end of any sort of business transaction or legal issue that can pay dividends down the road.
Awesome. Hanna, Melissa, thank you for your time.
Thank you.
Awesome. That's a wrap. It's on today's episode of Deals and Disputes with West, Webb, Albritton, and Gentry. To learn more about the firm or hear past episodes, visit westwebblaw.com. Thanks for listening, and be sure to like, subscribe, leave a review if you found this episode helpful. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.